This is the FM Gold channel of All India Radio. In the program News Analysis, now we bring you a discussion on Supreme Court verdict on triple talaq. The participants are Amit Khemka, legal expert, Naz Asghar, senior journalist, and Satya Prakash, journalist.
In an important verdict, the Supreme Court has declared the practice of triple talaq as unconstitutional. This practice has been in India for centuries among Muslims, and as a result of this practice, thousands of Muslim women have been facing lots of difficulties, and it was on their petition that the Supreme Court has given this verdict. Mr. Khemka, tell us, what is this constitution bench verdict?
Let me first of all say that this is a day for a new beginning in our country. It is another thing that we never expected the judgment. We always thought that the judgment would be a unanimous judgment, because if you look at it from any point of view, it is inhuman that a person in any mental state can just say talaq, 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 and he can get out of the marriage. So it was actually a question of human rights, if you ask me. That aspect was not exactly dealt with. After all, it should have been dealt with from the angle that the human rights of the woman have to be protected. Take the example of misogyny. The misogyny is prevalent for centuries in every society or every religion. But do we not undertake reforms? Do we say that since misogyny is prevalent, therefore the misogyny should continue? The patriarchal mindset should continue? This one thing is a symbol of patriarchal and misogynistic mindset. And therefore, it should also have been attacked from that point of view. But still I am very happy that at least the majority judgment has legally struck it down.
For our listeners, let me clarify, this verdict was delivered by a majority of 3 each to 2, and the majority said this practice of triple talaq is unconstitutional, and the minority said since lots of reforms have taken place across the globe in Muslim law, the court used its extraordinary power to restrain Muslim men from exercising this right. That's the minority verdict. But in the end, the minority verdict requested the government and parliament to enact a law within 6 months so that this can be done away with. But this majority verdict, how important it is?
The majority verdict, as I was trying to explain, what they have said is that since the 1937 Act, which recognizes the law of Sharia, which says the Muslim Personal Law Sharia Application Act of 1937, says that law of Sharia has the legal sanction. And because of that, the triple talaq also has the legal sanction. And as it has the legal sanction, it cannot be arbitrary. And it has to stand the test of Part 3 of the Constitution.
That is fundamental rights.
That is the fundamental right.
Now, from a point of view of a Muslim woman, how important is this verdict and how is it going to impact the Muslim society?
I think you may question the details of the judgment or that it has not gone very far in ensuring the human rights of women. But I think it will have some good, number one, very psychological effect on Muslim women, because now they feel that the law which passes off as Islamic law, this triple talaq, because it finds no sanction in Quranic text. So this law, which has just been there because of the male-dominated society, now women think the law can come to their rescue. And this law, which was really un-Islamic, can be questioned.
You said it will give them confidence.
Yes, it will give them confidence.
And the second point, it is un-Islamic law, or rather it was un-Islamic law, because many of the Supreme Court judges who dealt with the issue in this constitution bench, they also mentioned it is against the Quran, yes, and some of the hadith sanctioned it, but there are contradictory versions of hadith, and that is why the court said hadith cannot be relied on for this particular purpose, and in any case, Quran specifically says it's sinful. Once the Quran says it's sinful, it cannot be permissible under Islamic law. But then despite that, it has been in practice for centuries. How come?
I think it suited a male-dominated society. So it was there and nobody could not challenge it.
Actually, there are Islamic countries,
theocratic states,
which have already declared it as illegal. Take example of Pakistan, take example of Saudi Arabia. So there they don't practice it. We call ourselves a secular country. We say that we want to go towards the uniform civil code. That is what our founding fathers asked us to do. We may not have done it in 70 years, but that is what was the desire of our founding fathers, that we must go for uniform civil code. We must have a society where religion must only be a personal matter. It should not affect the second human being, according to me. But being a personal matter must be that whatever, it is my own matter. It cannot affect even my wife. It cannot affect even my children. It should not affect my parents. So no other person should be affected by the religion. It is a personal affair, no doubt. That is the meaning of secularism which our founding fathers wanted to give. So even in that society, we have not bothered to do anything in that direction. So that is the very...
This reform should have come much earlier. And in this, I think this Muslim Personal Law Board has played a very regressive role. And I don't know why it should be considered a lobby for Muslims, because I don't think majority of Muslims are so much looking up to Muslim
Personal Law. That is a very important point Madam has raised. Who are the representatives of a particular religion?
Because in this case, all the petitioners, they were all Muslim women or Muslim women groups. But interestingly, even the court has termed the entire this practice as a retrograde and unworthy of protection.
The words used by Justice Kurian are very interesting. He says what is Quranically wrong. He says even something which Quran does not recognize. How can that be legally correct?
Justice Kurian's judgment starts with Quran and ends with the Quran. But he has also dealt with the issue of arbitrariness in this entire practice, which is also one of the important aspects dealt with by the verdict delivered by Justice Nariman. Because he said this entire practice is arbitrary and hence it is violative of Article 14 of the Constitution. But one important issue that the verdict has dealt with is the issue of Shariat Application Act of 1937. And Justice Nariman has said, since this law is a law within the meaning of Article 13, it can be tested on the touch...
of Section 2 of the 1937 Act.
Yes. He said it can be tested on the touchstone of constitutional principles and provisions. How important it is that, Mr. Khemka?
To my mind, it will actually now be a very, very big beginning. Because once you say that the whole of law of Sharia is now subject to the constitutional test. The test, it will have to stand the test of constitution. So the meaning which comes out of that is that every other practice of Sharia or every other law of Sharia will now or can now be tested on the constitutional parameters.
So it will have to fulfill the requirements of
fundamental
equality,
rights, non-discrimination.
And
when it comes to personal law or the religious freedom, then of course Article 25 will come in. And although hardly any of the judge has agreed that it is Article 25 which protects it from the touchstone of fundamental rights.
Naz,
this judgment has done one more thing, because Sharia is sometimes thought to be equivalent to the Quranic injunctions. But Sharia is a codification of law in the light of Quran, but it is subject to various interpretation. Sharia laws are itself not Quranic law in essence, in the sense they can vary. There can be varying interpretation. Suppose one particular verse of Quran deals with talaq or something, marriage. Sharia based on law is just a codification of that law, and then a human element comes. Those who are believers, they say Quran is divine.
There are various schools also.
Yes, various schools also. One can say Quran is divine, but those who are believer in God, they say yes, believing divinity or not, they can say Quran is divine. If suppose Quran is divine according to the believers, but then Sharia is not divine.
On the touchstone of Quran also.
And prevailing circumstances, requirement of the society, interpretation of Quran in the light of those. Even in Islam, there is a provision for ijtihad. You can improvise according to the needs, the times.
One particular thing, and which is quite interesting, that the judges, they have tested this practice of triple talaq, both on the touchstone of constitutional principles and Quranic verses. In particular, Justice Kurian Joseph, he has emphasized the fact that what is sinful in theology cannot be valid law. And they have avoided hadith because there are conflicting interpretations of hadith available. But further, one particular aspect, at least 3 judges, Chief Justice Kehar, Justice Abdul Nazir and Justice Kurian Joseph, all 3 they have talked about Parliament enacting a law. In that context, particular Chief Justice and Justice Nazir, they have also mentioned Article 44, which is about Uniform Civil Code. This entire debate about personal laws and various types of personal laws of various religious groups in India, can there be a Uniform Civil Code? And if it can be, what kind of shape it can take?
No doubt, what should be the Uniform Civil Code is a complex question. We cannot hide away or we cannot just avoid that. But then it is not an impossible thing to do. After all, a large number of countries in the world have laws related to marriage and property which are uniform. After all, how has it helped the Hindus to have a different law for Dayabhaga and different law for Mitakshara? It has created more problems. It has created more litigation. It has created more complexities rather than solving them. If you have a simple law on property, if you have a simple law of inheritance for everybody in the country, how is it going to affect anybody's religious freedom or anybody's religious belief? For example, you may get married whatever way you want. You may do it by nikah, or you may get it by saptapadi, or you may get it by any other means. But after you get married, your talaq, divorce, should be regulated by the law. What can be the problem in that? How does it interfere with one's religious freedom or religious belief?
What you are suggesting is the consequences of marriage or divorce should be the same for everybody.
For everybody.
You may go in for marriage or divorce as per your own religious practice.
Let me give you an example. If one person in marriage is doing cruelty to the other person, of course, the other person should be entitled for a divorce. How is it connected with the religion? Can there be any religion?
Or can there be religious sanction for such kind of
a cruelty?
This is just the beginning. There are many people are saying. Just the instant form of triple talaq. But there are lots of other issues relating to Muslim personal law, which the court chose not to touch in this round of litigation. The issue of polygamy, issue of halala, and issue of maintenance also. Can there be another round of litigation?
It's just a beginning, because all these issues are very complex. To study them, to have a very comprehensive view of all their consequences. So I think it's not easy to deal with all the issues by one constitution bench.
Now the politics of this country, irrespective party lines, must take charge.
Here I would like to make one point.
Yes.
This issue of civil code, I think it should not be, projected as if it
should not be
only
projected
affect
like
Muslims. I think the Uniform Civil Code is a very complex matter, and even in Hindu society there will be a lot of resistance when you finally go for, because there are so many income tax laws on which Hindu undivided family is the beneficiary. So it should not be projected that it's just Muslims are resisting it. The resistance may come from other sections of the society also. But we have to go forward. We cannot move backward.
We cannot be backward.
The verdict has been welcomed by Prime Minister Narendra Modi, many opposition leaders and all of us. The civil society has welcomed it, various rights groups and Muslim groups. But the Muslim Personal Law Board has said that it will take a final view on this issue. In Bhopal, they have a meeting next month. And thereafter, they might take a decision to further go for litigation or file a review petition. But let's hope that this proves to be a good beginning, where the rights of Muslim women are secured and they feel secure in a democratic India.
So they make a big beginning with these enhanced rights.
Thank you.
You were listening to a discussion on Supreme Court verdict on triple talaq. The participants were Amit Khemka, legal expert, Naz Asghar, senior journalist, and Satya Prakash, journalist. This program was produced and presented by the News Services Division of All India Radio. This program is also available on our website newsonair.nic.in. You may email your opinion about this program at airnsdtalks@gmail.com.